they wouldn't be able to then come after your personal assets to satisfy that judgment. If you attended the live that Katrina and I did last week, we dove in a little bit about the differences between an LLC and a corporation. They both act as this wall around your personal assets. An LLC has less formalities, so less paperwork. If you're wanting investors down the line, a corporation is probably the way you're going to go. They have different tax consequences, so it's really important that you talk to not only a lawyer, but an accountant as well when you're making the decision between which one to choose. So the reason that the formalities and the paperwork comes up, so a corporation, like I said, there's more paperwork, there's like minutes, there's meetings. If you don't file those corporate formalities, creditors can do what's called piercing the corporate veil. So your corporation is only as good as how you keep it up. So if you're running a business, but you're paying your personal expenses with your business credit card, or you're not keeping things separate, and you don't follow the formalities, that shield disintegrates and people can come after your personal assets. So the best thing you can do is pick the structure that you're going to be able to keep up with. Most people choose LLCs if they're not worried about like investors or foreign investors, things like that. That's what I see most often. So mistake number 2, not having contracts. So this is what I specialize in. I have a website where I sell contract templates for people who don't want to spend the $1,000 or so getting a custom contract, because contracts are like the main thing you need between you and your customer to protect your income. So there's different types of contracts we'll get into, but basically all contracts are going to name the parties. They're going to establish expectations and the boundaries between the parties. They're going to define the scope of the project, the scope of work, what deliverables are being given. So if you're a graphic designer, you know, your logo. And it states how you'll be paid and what happens when a party fails to pay. So what the consequences are. They also decide like how you can terminate the agreement, and how disputes can be handled. So is it going to be mediation, arbitration, court? Are you going to be entitled to attorney fees? Is there a mandatory mediation before you can sue someone? If you're located in Florida, you know, you want to say you're in Florida so that somebody doesn't sue you in Kansas, things like that. And we'll dive into a little bit more about contracts. So the first one you're going to want is that contract that you have with your clients. So this is going to say what you're responsible for giving your client and when and how much you're going to be paid. So I always recommend before you get into like your independent contractor and your NDA that you have a client contract in place, just because that's where your money is coming in. So the next one that I do a lot of are the independent contractor agreements. So this is when somebody's not an employee, they're just somebody you hire for a part-time or a project-based basis. And what this contract is going to do is basically say they're not an employee, they can't take your employees or customers, and they have to keep your confidential information a secret. And this is really important if you're in an industry where you do have some kind of proprietary secret business information that you want to protect, and you have people coming and going from your business, and you don't want somebody copying your business or stealing your designs or things like that. On that same train of thought is an NDA. So if you just need an agreement where you're maybe meeting with somebody, with a consultant or a potential employee, and you want to protect your confidential business information, this is when you'd have them sign an NDA. So these are some of the important terms that you're going to want in your agreement. So one common mistake I see all the time is the first line of your agreement where the parties are, and people put their individual names to the contract. If you have an LLC and you're working through that business structure that we talked about earlier, you're going to want to make sure that your business name is that party name. So next, the term of your agreement, you want to specify that there's an end date. So whether it's a year or 2 years, you don't want an indefinite amount of time. Um, you know, not only for like the validity of the contract, but you don't want to be, you want to know how long you're locked into something. So if your contract provides that you can't work for another company, another similar company after you leave that company, you want to make sure the term is like a reasonable term, a reasonable amount of time, that it's not just like, if you work for my graphic design company as a contractor, you can never work for a graphic design company again, things like that. So your scope of work and your deliverables, that's really like outlining your project. So what are you giving somebody under the contract? What are they giving you? What does it encompass? So I see this come up a lot in those like web graphic design videographer contracts, where you want to be really specific about what you're giving the client, because the client will rely on that, and you can go back to that and say, no, I promised you like a 10-minute video, not these clips. And this is where you get really specific about like how you're going to deliver that. So is it like a JPEG? Like what format are you delivering these deliverables in? So payment terms, really important. When you get paid, is it based on a date? Is it based on an event happening? How you're going to get paid? Is it Stripe? Is it Venmo? Is it check? Is it credit card? You may want to have like a chargeback clause in there that says, if, before you institute a chargeback, you have to do X, Y, Z. I see that a lot. In most of the contracts I draft, clients want that in there, because that has become such a problem with clients like receiving services and then just disputing the charge with their credit card company. And unfortunately, a lot of times the credit card company will just side with the customer. So to provide like some relief for that in the contract, I see that a lot lately. So your intellectual property is your copyright, your trademarks. If you're, I'm using the graphic design contract example because it's easy, but if you're creating a website or a logo for somebody, you want to specify whether the client owns that or whether you still own that and they're just licensing the rights to that. So I know for like the photographer I use, in her contract, it states that she owns the intellectual property of those photographs and you have a personal license to use them on your social media. So that means that like you can't go use that in a commercial setting. And just specifying who owns the intellectual property. So whether that's you, whether that's the other party, it's just really important to put in there who owns what. Okay, so a non-solicitation clause is what I spoke about in the independent contractor agreement. And that's basically saying if you work for me on a part-time basis or a contract basis, you cannot take my clients, you can't take my customers, you can't solicit these people from me. That's a condition. And you won't always see these in like a client contract. But you might. Like I have a graphic design friend who wanted a non-solicitation clause because she uses subcontractors and she didn't want that client to go steal those people and get work from them cheaper, and instead of going through her. So force majeure basically says if for any reason like a hurricane or some acts of God, something like that, I have a way to get out of my contract. So this clause became very in use in COVID because people would say, okay, well, yeah, you rented. So say I signed up for a yacht and I was going to have like a wedding on a yacht. I would then rely on that clause to say, okay, well, COVID, there's regulations preventing gatherings. So acts of God, I can't come, I need a refund. And this actually happened to a client of mine where she had to refund all of this because of this clause. So now a lot of times in contracts, you'll see people saying COVID is not a force majeure event anymore because we know about COVID. You can't blame it on COVID and get your money back. Termination, this is just how you end a contract. So usually you'll see whether contracts can be terminated for cause or not, or they can terminate, people can terminate it for any reason. So sometimes like in a brand influencer contract, the brand will be able to terminate it for cause. So if the influencer does something that like embarrasses the brand, if they're involved in some kind of scandal or if they lie, the brand might say, okay, our termination clause says that we can terminate, for cause, and you have met a for clause, definition. And a lot of contracts say like either party can terminate with no cause, and you have to specify like what happens. Like, does the party get all of their money back? Do they get some of it back? You have to be really specific, because when somebody wants to get out of a contract, this is the clause that they go to. Indemnification and disclaimer of liability have to do with who is responsible and for what if something were to go wrong. So this is another really important provision in your contract. Basically, there's a bunch of different disclaimers you can have in your contract, whether that's an earnings disclaimer. So if you're a finance coach and you're saying, buy my course, I guarantee that you're going to have financial success, and you make all these representations like in your pitch, your contract is likely going to have something that says, I don't guarantee success. I hope that you have financial success, but if you don't, it's not my fault. And you'll see like all that legal language that you hear on like commercials, like allergy medicine commercials. That's like your disclaimer of liability. And it's especially important if you're in like a finance, legal, health field. And that's kind of ties into limitation of damages too, which basically says like we can't be held liable for punitive damages. There's all different kinds of damages that you can recover against somebody, and this clause really like limits those. So dispute resolution. It's funny because I see a lot of contracts lacking this clause, and it's really important because it says like if everything else in this contract goes wrong, if I'm suing you based on any provision of this contract, this is how we're going to handle that dispute. So in a lot of my contracts, I put in like a binding mediation paragraph that says, if you have a problem, if you're suing me, you agree that we're going to first settle this in mediation. And then we can go to arbitration. Then we can go to court. Other contracts say we'll go straight to court, we'll go straight to binding arbitration, which is like more of a private setting than court. Court, everything is public. And your dispute resolution will say if the winning party gets attorney's fees. It'll also say where, so like city, state that this is happening. Unfortunately, like if you don't pay attention to this in a contract you're drafting, or especially in a contract you're signing, you may be agreeing to have any kind of dispute be held in a state where you don't live. And that's a pain because that entails hiring somebody, finding a lawyer in another state, first of all, who's qualified, hiring them, showing up, to court proceedings. Now everything's virtual, but before you'd have to fly. So really big pain. You want to make sure any dispute resolution is in the city that you live in. Okay, so mistake number 3, not having website policies. This mistake I see every day, and it's because nobody wants to deal with them. They're like what you see in the footer of every website. So go to any website, like Target, Walmart, anything, any big commercial site, you'll see a terms of use, a privacy policy, disclaimers. You might see like a refund policy, or just like a tab that says legal that has everything in there. but they're really important. Your terms of use is basically your contract with anybody who visits your website. Your privacy policy is legally required, and it tells users how you collect and store user data. And your disclaimers are required if you're in the legal, medical, financial industry, or if you're involved in affiliate marketing. So if you're making money off of something that you're promoting. So your terms of use is really important, and you might have one just for your website. You will also need one if you're doing any kind of like online course. You'll want a course terms of use. And it tells like your purchasers, your website visitors, what kind of comments they can post, what their user account policies are. It protects your intellectual property. So if you have like freebies on your website, or you have course material, any kind of like intellectual property, it states, you know, this is for personal use. This is not for commercial use. You can't share this with a friend. You can't reproduce this. It tells your user what your payment policies are, so what your refund policies are. If you're on some kind of like recurring payment plan, it gives you authorization to charge their card. And then it has that dispute resolution, which I mentioned, which is like very important, saying if you rely on my information on my website and you hurt yourself or something happens and you try to sue me, you have to do so in my city and state. Okay, so privacy policy. This is actually legally required. So this is legally required in the EU. The European Union has laws. California has privacy laws. And if you're collecting personal data, hi Katrina, I can see you. If you're collecting user data from anybody there, which you don't know if you are, right? So like if you have an opt-in form where you're collecting email addresses, that's collecting user data. I have no idea personally if I have anyone from the EU or California. I'm sure I do. And because I'm doing that, I'm now subject to the EU and California's privacy laws. It's also legally required if you run Google or Facebook ads or have Google Analytics. So these third parties require you to have a privacy policy on your landing page. And your privacy policy basically is like, you tell them what you're storing. So are you storing their name? Are you storing their email address? Are you storing their social security number, their credit card? You have to actually state that in the footer of your website. And you have to give them a way where they can opt out of that. You have to talk about your cookies, a lot of technical stuff. But really important to have, and it's complicated and intimidating, so not a lot of people have it. Not having, and the penalty for not having privacy policy is you can get fined by the government, like thousands and thousands of dollars. You can also get sued by these private parties whose information you have taken. So it's both a private cause of action and the government can fine you. So not something you want to mess around with. But mistake number 4 is not having disclaimers. So as I mentioned, really important, like if you're a supplement company, you need to have specific wording that the FDA requires you to have. If you're in the legal profession, like you can see on all of my emails on my website, I have, you know, this is not legal advice. Like this is information only. Do not rely on what I'm saying, as like, I'm not your personal attorney. Also required if you are receiving money for a product or were given a product for free in exchange for an endorsement. So if I, if like Pottery Barn sent me something, like sent me a blanket and they're like, hey, can you give us a shout out? Like, even though they didn't pay me, they just sent me something for free, I would still have to do, I love my blanket, it's so soft, #ad, and do their like very specific hashtags that you're allowed to use, very specific ones that you're not allowed to use. You're supposed to make them, like if it's a story, if it's video content, you're supposed to say it like out loud, like, hey, Pottery Barn gifted me this blanket. and you're supposed to have it written. So there's very specific like disclaimers you need to have not only on your website, but in any kind of like blog post, Instagram post, Instagram story if you're promoting products. So these are a few disclaimers that I've just listed that you can go back to for future reference, but basically, like I include all of these in my website terms of use template, just so people can like pick and choose. But basically saying like, I'm not warrantying anything. If people are commenting on my picture on my website, they're making comments on my blog posts, I'm not responsible for that content. So if you're offended, like sue them, not me. Earnings disclaimers, what I talked about with like coaches making claims, kind of like, I can increase your sales. And then maybe somebody's sales don't go up and they're like, well, you told me they'd go up. And you're like, well, look at our contract. It specifically says like, I'm giving you the tools and I hope that you follow them, but like, I'm not responsible for your financial success. I don't guarantee your financial success. Professional client relationship, sort of like what I talked about with the legal, like we do not have a lawyer-client relationship. If you're an accountant, you will want to have that finance person, really important. Definitely like a health professional, you'll want to say like consult your doctor, things like that. Copyright disclaimer, basically like this is my copyright. Which leads me to mistake number 5, which is not protecting your intellectual property. So there's different types of intellectual property. You may have heard of copyright and trademark. They're the most popular. So copyright protects like your videos, your photographs, your ebooks, your courses, your blog posts. It does not protect ideas or concepts. Katrina told me a great story. I don't know if you want to hop on here, Katrina, or I can tell it, but basically like there was an event and somebody basically—
Go ahead and tell it. Just—
You want me to tell it?
Yeah, take it away.
Okay. So, and you can jump in here at any point, but basically she had an event, or her friend had an event, and it was a very like, there were specific themes to the event, specific like workshops in the event, and somebody basically stole the event, changed the name, but took everything and did everything the same. And the sad part about this is there's really nothing you can do about it because you can't trademark an idea, you can't trademark a process. What you could trademark or copyright is the name of the event. So you can trademark words, phrases, symbols, or designs. So if you have a course name, or you have a brand name, or you have an event name that is like you use all the time and you don't want somebody stealing, you can trademark that. And you just do like a cost benefit analysis. It's, I think most attorneys charge like $2,000 to $3,000 to trademark a name. But that's your intellectual property. And the only way that you can sue somebody for intellectual property violations, so if I had a picture, like say I took a beautiful picture and it was really popular on Instagram and people started reposting it, claiming it as theirs, I can't sue them for violating copyright law unless I've actually registered that photograph with the US Copyright Office. So copyright is automatic. So I own the rights to that picture. That's mine, it's my copyright, but I actually can't sue them under the copyright statute or get damages, which is like $25,000 per violation, unless I've gone ahead and registered the picture with the Copyright Office. And same thing with trademark. So you will want— a trademark is not automatic. You actually have to like, you do not own the trademark unless you affirmatively apply for it. So I would really recommend protecting your intellectual property from day one, because you can't then say, oh, I'm going to copyright it, somebody stole it. It's not retroactive. So unfortunately, in this industry, in the online space, there are a lot of copycats and there are a lot of people. I mean, I think I've gotten my account hacked like 25 times this year, not hacked, but like my pictures taken and put on these fake accounts. And unfortunately, I think these people just live in another, like on the other side of the world, where my recourse is really, I'm not going to sue them. It would take too much time and money, but I can ask Instagram to take it down. So I'm going to go over what to do when your work is copied like that. A few steps you can take. So you can notify the person that they're infringing on your copyright. So I could DM these Bitcoin people and say, you know, these are my pictures, please take it down. Probably not going to work. I could send a DMCA takedown notice, which is basically like contacting the person who owns the domain. So say my pictures were stolen by a Bitcoin person and they put it on a website that was hosted by some other third party. I could contact that third party and say, hey, your website's violating copyright law because this is my picture. And they can actually take it down themselves. And that's like one way to get around somebody who doesn't want to take it down. Third, you can send a cease and desist letter, which is basically an angry lawyer letters. I write these a lot, and I would say they're like 85% effective. Just sending that letter and just saying, you know, I represent so-and-so. Please note that you're in violation of copyright section, you know, US statute, blah, blah, blah. And if you don't take it down, we'll be suing you for X amount of dollars. So this actually is pretty effective in getting people to take things down that they know that they shouldn't be using. But it does require like finding a lawyer, hiring a lawyer. So you're kind of at that next step. And then your final step, which is going to cost you probably like $10,000 just to start a lawsuit, is filing a lawsuit against somebody who's taken your intellectual property. And like I said, if it's a copyright violation, you can't sue them under the copyright statute unless you've protected it, unless you've registered it beforehand. So that's a step you can, if you are like a photographer who regularly copyrights their pictures, and that's just, you're in the habit of doing that, you will already have protection. And then if somebody does that, then you'll file a lawsuit under the copyright statute. Let me look at my notes, see if I have anything else, because I think we are nearing the end. I want to go over just like a couple ways to not get sued. So first of all, not making these mistakes, right? Like have your website policies. It's very easy. I have made it very easy if you don't want to do it yourself through my templates. It is just like a quick preventative measure you can take to avoid hundreds of thousands of dollars in attorney's fees down the line. Have a contract. Don't take other people's intellectual property. So if you're reposting something, technically, like you're supposed to get permission to repost. Nobody does this. The internet laws are like way behind what's actually happening. But if somebody tells you like, hey, this is my picture, please take it down, like take it down. It's not something you want to mess around with because like I said, it's $25,000 per violation. Read your contracts. So nobody likes to read contracts. I don't even like reading 20-page contracts when I get them to sign on something. But I just dealt with a client who had an SEO company that she hired, and it was a 3-year contract, and it was buried in the terms of her contract that it was 3 years. And you actually had to click a button in the contract to be taken to a separate terms of use page where they said it's a 3-year contract. It not only said that, so this company was just not performing. She wanted to get out of the contract. In order for her to get out of the contract, the penalty was she had to pay all 3 years up front. So she had to pay $30,000 up front if she wanted to get out of the contract. So she played hardball with them, obviously, because this wasn't fair. This wasn't what she agreed to or thought she agreed to, because it was buried in the terms of use, and because they just weren't performing. She was pissed. She just wanted to be done. So she didn't do that. She did not pay them $30,000 right away. She just stopped making the monthly payments. Also buried in her contract was language that they now own the domain. Like, and they were hosting it. So they had access to her email. They controlled her emails, like her business emails. So they actually shut her emails down. They shut her website down. So her main business was completely paralyzed, and she was held hostage until she paid. And, we got it down. I think we settled it for less than 30, but she had to come up with that amount of money just to have control over her own business again, all because she didn't have a lawyer review her contract, or, focus too much on the fine print, which is like, this isn't, and she's very educated. These aren't mistakes that like only non-educated people are making. Like, all of my clients who I see who are in these messes are like 6, 7, 8-figure, intelligent, like the most intelligent women I've ever met. These are common mistakes. So it's not like, there's something wrong with you that you're making these, because the only reason I know about them is because I've lived it day in and day out for 7 years. So don't feel bad if like you don't have any of these and you're just getting started, because just the fact that you're educating yourself and making yourself aware of them is putting you in a completely different ballgame than your competitors. So I know we have, Katrina, do we have time, like Q&A next, or?
Yes, I have some really good questions. So we have one here. It says, "Hi, Berkley, can you help with trademarking my business?" So speak to how that would work.
Yes. So trademark is like a really specialized area of the law. So I have somebody that I hired to do that, who's like a trademark expert. So I have my business with my contract templates, and then I also do like one-on-one client work where we go through the trademark process and like the trademark searching to make sure the name's available, and like that whole process.
Why don't you take us to the last page, Berkley, so that if someone does want to reach out to you, they can have that information. Perfect.
Yes. And I forgot to mention, if you want to learn more about like the steps you need to take, like I have a free legal startup guide. It's in the link in my Instagram bio. And it basically is like a detailed checklist guide of like everything you need to do legally when you start a business. So it's a really good resource if you want to check that out.
Yes. Awesome. Okay. So, how do I find a privacy policy that I can put on my site? Does that have to be custom?
No. So I've made a really easy fill in the blank privacy policy. It takes like 10 minutes to 20 minutes to fill out. And it has all of like the necessary legal language, like to be compliant with the European Union privacy laws and the California privacy laws. And basically it comes in a PDF Word download. You plug in your information in the Word download and you put it in your Squarespace WordPress like footer for your privacy policy.
So just to be clear there, you said California and EU. Is California just separate from the rest of the US? Is that why?
They just have privacy laws. So like not every state has internet privacy laws.
Got it.
But they're strict. They're very consumer friendly.
Okay, so next question. How expensive is it to have a custom contract made for my business? I know I need it, but I'm not sure I have the budget. Haha.
Usually they're around 1,000. And I calculate that because I usually it really depends on the client. Like some contracts take me 3 hours. So if I'm billing at like 300 an hour, it's like 900-ish, but it also like, I don't like to put revision caps on it. I do sometimes, but I never enforce them because I want somebody to be really happy. So like I've gone back and forth. For instance, I have one client, I've been working on her contract for 2 months. I love her, but it has been like 10 hours, right? But I'm not charging her $3,000 because it all,
So essentially a custom contract would take talking to you, but do you have templates that someone could take as a coach, or I don't know what this person does exactly, but let's say a photographer, do you have all of that within your website too?
Yeah, so I have client contracts like for web designers, graphic designers, coaches, content creators, brands who hire influencers, and then like a standard independent contractor. So if you don't fall into any of those, also like a social media manager. Yeah, if you go to like the shop template page, it lists all of those. But I do have, and it's the same like fill in the blank.
Perfect. Okay, so can I switch my next question? So can I switch my business from a corporation to an LLC?
You can switch it from an LLC to a corporation.
Mm-hmm.
I don't think you can do the reverse.
Yikes. Okay, that's interesting. So what would someone do in that situation?
I would speak with both your accountant and your corporate lawyer, and see what the best path is, whether it's dissolving it
Mm-hmm.
and forming an LLC. There might be loopholes, honestly. This is not, I don't do a lot of entity formation. But I would definitely talk to both of those professionals.
Perfect. Okay, so next question. How would the government find out that I don't have a privacy policy? Does someone have to report me?
So the government's like probably not worried about you, right? If you're running a bigger business, like just Google like government fine privacy law, and you'll see like Facebook getting fined $3 million. Like Google getting, like big companies getting fined. So the chances of like the government fining you if you're an individual, probably small. They have bigger fish to fry. They have limited resources. You're probably more likely going to get in trouble with a private individual who's pissed for some reason.
Mm-hmm. Okay. Okay, so last question I have is, do I have to disclose if I'm an affiliate and I'm sharing things on Instagram?
If you're making any kind of compensation, so if you're an affiliate and you get like 10% of the commission for any like sales you make, yes, because you're getting compensated.
Yeah, so how do you know what to say? Is there somewhere that you can guide them to go to figure
Yeah,
that out?
so I have a disclaimer template. I think it's like $70 or $90 on my website. And it has like all of the disclaimers that I mentioned here, one of which is the affiliate disclaimer, where it says like the language for the blog post for like what you need to say.
That they would be getting all of the things that they should be putting on there for whether they're an influencer, whether they're an affiliate, like those are all in one.
It's one, yeah, it's just the affiliate disclaimer.
Got it. Okay.
Is what I call it. Yeah. And look at the legal startup guide, because I think I put a little bit of that in there too.
Okay, perfect. So helpful. I know I get questions like this all the time, and I'm not a lawyer. So this is amazing that there's somewhere to actually guide them to. So if you are asking questions around any of this, the next step that I would say is go download the totally free template and see what you need to do in your own business and take it from there before you do anything else. Fair?
Yeah, fair. Or, I mean, I'm like, you can email me, DM me if you have questions.
Perfect.
I answer most of my DMs.
Just most.
I had a sugar baby request last night. I didn't answer that one.
So that one, oh, we have one more that just came in. Okay. Do you have any employee contracts, or do you write up policy and procedures? Do you have employee contracts, or do you write up policy and procedures?
I have an independent contractor agreement, which is a little bit different than an employee contract. And I do those only for people in Florida just because employment law is a little state specific.
Got it. So Joy, I hope that answered your question, but feel free to reach out further to Berkley if you have anything further. So I think we've answered everything that came in. I'm just checking one more time. Yep. And yeah, so I will share all of this information, and everyone here will get the replay, and you are welcome to reach out to Berkley via DM or email.
Perfect.
Perfect. Okay, thank you so much.
Thank you for having me. This was great.
You're wonderful. All right, I will talk to you very soon. Bye, guys.
Okay.
Thanks for being here.
Bye.
Bye.